Federal judge blocking the Trump administration from revoking the legal status of more than 500,000 immigrants.
Hello, welcome to the U.S. Immigration News. This is the first good news in favor of immigrants since Donald Trump became the U.S. president. In a dramatic shift in U.S. immigration enforcement, a series of federal court rulings have given a major blow to the Trump administration's immigration crackdowns. In recent developments, judges have stepped in to block efforts to swiftly remove certain non-citizens under an archaic law, raising significant legal and constitutional questions. Officials claim that the policy was designed to address national security concerns, while critics warn that it could undermine essential protections and due process. In this video, we will break down all the details of these rulings and explore the major implications for your immigration journey. If you are interested in this topic, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. In recent months, the U.S. immigration landscape has been rocked by unprecedented policy moves and equally dramatic legal pushbacks. The Trump administration, doubling down on its signature approach to tough immigration enforcement, resurrected a centuries-old law, the Alien Enemies Act of 1798, to expedite the deportation of Venezuelan nationals with alleged ties to the notorious Tren de Aragua gang. Declared a foreign terrorist organization by U.S. officials, Tren de Aragua has become the focal point of a contentious effort to bolster national security by swiftly removing individuals deemed as threats. From the moment this controversial policy was announced, legal challenges surged. Immigration advocates, civil liberties groups, and human rights organizations warned that using such an antiquated statute to target Venezuelan nationals risked wrongfully detaining innocent people. Many of those caught in the net were fleeing violence and persecution at home, seeking refuge in the United States, only to find themselves accused on the basis of unverified gang affiliations. Critics argued that broad, hasty enforcement efforts under the Alien Enemies Act could trample on constitutional rights and jeopardize lives by denying due process. The administration, however, maintained that the gravity of the threat posed by organized crime justified immediate and decisive action. Supporters argued that the government must act without delay to prevent criminal networks from exploiting America's borders. They claimed that when national security is at stake, swift deportation measures are not only justified, they are necessary. This situation set the stage for a profound debate. Is America's strength defined by uncompromising national security measures, or does its character depend on the unwavering protection of individual rights through due process? At the heart of this debate, the federal courts have played a pivotal role. Shortly after the administration started invoking the Alien Enemies Act, 2 Venezuelan men in Colorado were detained on suspicions of gang involvement. Their attorneys, in collaboration with the American Civil Liberties Union, rushed to the federal courts, arguing that deporting these men without proper hearings violated their constitutional right to due process and put their lives at risk. On April 15, 2025, U.S. District Judge Charlotte N. Sweeney delivered a landmark ruling by issuing a temporary injunction that barred the deportation of anyone in Colorado detained under the Act. According to Judge Sweeney, before any removal could occur, each individual had to be granted a proper hearing to assess whether they posed a genuine threat or were being unjustly targeted. This decision sent shockwaves through the legal community and resonated far beyond Colorado's borders. Almost concurrently, federal judges in other jurisdictions issued similar rulings. In Texas, Judge Fernando Rodriguez Jr. issued a temporary restraining order preventing the relocation or deportation of Venezuelan detainees in the Southern District. In New York, Judge Alvin Hellerstein followed suit, and in Boston, Judge Brian Murphy blocked the removal of migrants bound for third countries, ensuring that each affected individual had an opportunity to argue that deportation would endanger their safety. Collectively, these judicial interventions underscored a fundamental constitutional principle. Due process cannot be sacrificed, even when national security is invoked. The Trump administration argued that the urgent threat of international crime demanded a free hand in enforcing immigration laws. In contrast, the courts made it clear that constitutional protections do not vanish in emergencies. Every person, regardless of alleged gang affiliations, must be afforded the chance to challenge their removal in a fair and impartial legal proceeding. For many Venezuelan nationals, along with migrants from other regions facing similar uncertainties, these court orders have been a lifeline. Human rights organizations have documented the dire conditions in Venezuela, where political turmoil, economic collapse, and pervasive violence leave many at significant risk of harm if deported. In these cases, a swift return could mean exposure to torture, persecution, or even death. Beyond the immediate impact on individual lives, these legal battles raise broader questions about the future of U.S. immigration policy. They force us to consider what kind of nation America aspires to be. Should the executive branch have unchecked power to impose rapid, broad-spectrum enforcement measures when security is invoked? Or must there always be judicial oversight to protect the rights of those caught in the system? Earlier this year, the Supreme Court weighed in by affirming that a hearing in federal court must be granted to anyone facing deportation under the Alien Enemies Act, a decision many hailed as a victory for civil liberties and the rule of law. Meanwhile, supporters of the administration counter that the Tren de Aragua is not an ordinary criminal gang, but a sophisticated and dangerous organization with international reach. They contend that detailed court proceedings could hinder efforts to combat terrorism and organized crime by allowing criminals to exploit legal technicalities to delay or avoid deportation. These conflicting perspectives epitomize an enduring tension in American governance, a constant balancing act between strong executive authority in times of crisis and the judicial imperative to protect individual rights. This balance, central to the nation's identity, is currently being tested in courts across Colorado, Texas, New York, Boston, and beyond. In practical terms, the recent rulings mean that before any deportation order can be executed, authorities must ensure that proper legal procedures are followed. This includes providing detainees with legal counsel, a chance to present evidence in their defense, and an impartial hearing to scrutinize any claims of criminal involvement. Although these measures may seem to slow down the process, for those facing the threat of removal, they represent a critical safeguard. The difference between life and a return to a dangerous, unstable homeland. Ultimately, these judicial interventions not only challenge the Trump administration's approach, but also set a vital precedent for future immigration policy. They stand as a powerful reminder that in the United States, the pursuit of national security must never come at the expense of the constitutional rights that define the nation's core values. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application, requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.